What is exceptional hardship in the case of getting a J1 waiver if you have a child? And if you are from India, that's what we're going to talk about in this case study. Even if you're not from India, you want to stay tuned because we are going to spice it up with some interesting J1 waiver case status updates on processing times, and we're going to talk about a case study. First of all, let's talk about the processing times because this is important to decide on your strategy when to apply. Here we filed the J1 hardship waiver on May 16th, 2021. The form I-613 was received by the Department of State from USCIS on October 17th, 2021. Then the favorable recommendation was issued by Department of State March 8th, 2023. So you can see here that it did not take USCIS that long to issue the I-613. However, Department of State took close to a year and a half to give a favorable recommendation, and then USCIS approved it within about approximately 15 days after that favorable recommendation. Total time here was a little less than 2 years. That's why I'm recommending that you plan for applying for this J1 exceptional hardship waiver. We're seeing ranges anywhere from a year and 7 months to 2 years. And I know when I have my consultations, many of you are shocked, like, 2 years. And it is crazy, yes, crazy, this amount of time, but it is possible to plan ahead to create a strategy. And that's why I like to keep you informed, so that way you know what to expect through this process. Along with those processing times, let's talk about the process for filing. So what we normally do is we file the DS-3035 and the I-612 concurrently. So the Department of State application is the DS-3035. The I-612 is the form with USCIS. Now you might look at it and be like, oh, this is so easy, it's just a form. Well, the form is just the basic info. What really matters are the documentation and the supporting legal arguments and the statement that goes with the case. So you have to blow it up with information, with facts, with legal arguments to create a compelling case. What we like to do is audit all the documents to make sure that you're supporting all of the arguments that you are making. And then from that, we use the documentation to create a legal brief explaining all of the legal arguments. Then we submit the application, and then it's a waiting game. Let's talk about how, in this situation, we were able to demonstrate exceptional hardship. So as I mentioned earlier, our client was from India, also a physician, and they have a young US citizen young child. In order to qualify for an exceptional hardship waiver, you need to have a qualifying relative. So a qualifying relative is a US citizen child, US citizen spouse, lawful permanent resident child, lawful permanent resident spouse. Our first argument is that we argued that the child's developmental needs could not be met in India. When appropriate, we also like to discuss the country conditions. So here, we also discussed the country conditions of India, and we extensively went into the variety of country conditions that occur in India that would make it difficult for this US citizen child. Now, I did mention that the qualifying relative is the US citizen child. That does not mean that we cannot discuss the actual parent's hardship as well, because the parents and the child are intertwined, of course. So we discussed the physician, the parent who's from India, the working conditions in India, and his ability to provide for his family would be very dismal for the family. Of course, we had to talk about why the child could not stay in the United States as well. So here we also talked about the fact that the spouse was a J2 holder. So therefore, if the J1 waiver is denied, and this is an important concept for you to note, that the J1 and the J2 are connected. So if the J1 is going to be denied, then the J2 will be denied. And in this case, we made that argument that the J2 would not be able to live here and take care of the child, because if the J1 waiver was denied or they had to go back and fulfill the 2-year home residency requirement, the child would also have to go back. So the child, of course, cannot be in the United States without the parents. We stacked all of these arguments together to create a compelling argument, and we were glad that USCIS agreed that this would be a form of exceptional hardship, that Department of State agreed as well, and we were able to get the case approved. Every case is unique, so I invite you to contact us to see if your case makes sense for filing. This is a subjective process where each officer is also bringing their own perceptions into the game. So contact us at 916-613-3553 to discuss this. Share this video with your friends so they stay informed. And of course, subscribe so you continue to get these videos. You are amazing because you are benefiting yourself by watching this video. By improving yourself, you're bettering your family. And by bettering your family, you're bettering the world. Bye for now.